Welcome to our Planning Live webinar. We are, of course, taking a look at infrastructure contributions, Section 75 agreements or obligations, and the infrastructure levy. Just to introduce today's panel of speakers, I don't think they really need an introduction. I'm sure you'll all agree it's a bit of a powerhouse panel today. They are, of course, our planning partners, Elaine Farquharson-Black, Karen Hamilton, and Neil Collar. So really a wealth of experience between them that genuinely spans the full spectrum of planning matters. So no doubt you'll be eager to hear what they have to say and to quiz them. And with that, I'm going to pass to Sarah Stewart. Sarah's a senior associate in the planning team, working closely with Elaine out of our Aberdeen office, and she's going to lead our panel discussion today. So over to you, Sarah.
Hello everyone, and again a very warm welcome to you all. So I'm just going to crack right on with what I'm sure is going to be a really interesting discussion. And I'm going to start with the Scottish Government's target to cut greenhouse gas emissions to net zero by 2045. Elaine, to what extent, if any, do you think we'll see Section 75 agreements being used to help achieve this target?
I would think, Sarah, based on past experience, it's highly likely. I am old enough to have seen, I suppose, various things come in and out of Section 50 agreements. That is actually how old I am. Section 50 agreements before they became Section 75 agreements. You know, so it used to just be open space. We spent a lot of time talking about whether the open space was going to the Greenbelt Company and that kind of thing, and was it going to be factored? And then, of course, roads. You know, education's obviously now a big thing, community facilities. I've seen percentage for art, you know, kind of policies. I've seen requests for funding of library books, all of these, you know, kind of aspects. So I would think it is kind of highly likely. But what you've got to remember, what councils have to remember, is just because there's a policy in the development plan doesn't make that, you know, a valid request, a valid, you know, planning obligation. And that's something that obviously came out of the ELSIC case, which is one that is very close to my heart, as most people will know, where there was a policy, you know, on strategic transport and funding the strategic, you know, kind of transport infrastructure. And the Supreme Court said there that just because you have a planning policy, you know, doesn't make it relevant. You can't make something that's irrelevant relevant just by, you know, embodying it, you know, in a policy. So, you know, bearing that in mind, the tests that, you know, the legal tests that were established, it must serve, you know, a purpose in relation to the development or use of the burdened land. And there must be more than that trivial connection. That's obviously where the STF fell down, that there wasn't any more than the trivial connection between the infrastructure improvement that was going to be funded, you know, by the development. The money was coming into a pot and then being used kind of elsewhere. So it didn't have that linkage. And I think Neil, you've got kind of experience of that, you know, fairly recently, where it kind of fell down for similar reasons.
Yeah, I thought it was worth mentioning because it is a recent example. The Scottish Government issuing a decision to West Lothian Council on their snappily titled Supplementary Guidance Developer Contributions Towards Transport Infrastructure. And it's really the same issue, in broadly speaking, as you had at ELSIC, because it is all about that connection. So I thought it was good to mention, just to show it is a continuing problem that planning authorities don't seem to have quite grappled with it and appreciated. And just to quote, like all good lawyers, it's so much better just to quote what the actual decision says. So this is the Scottish Government, John McNerney, Chief Planner, signing the letter. It has not, on the evidence being presented, been demonstrated that there is sufficient justification for seeking the full estimated cost of the proposed slip roads and town centre junction improvements from the sites identified, and it goes on, has not been demonstrated that such contributions will be fairly and reasonably related in scale and kind to the proposed development, blah, blah, as required by the circular. So again, it's just an example that the council may feel the contribution is justified, but they must have the evidence base. And for me, that was the key bit in John's letter. On the evidence presented, you've got to be able to back it up with evidence.
Okay, so Elaine, then taking us right back to basics, what are the tests for planning obligations then?
So as Neil mentioned there, we've got the legal tests, which I mentioned there for ELSIC, and then you've got the circular, which was updated in November kind of 2020 on planning obligations. And Neil mentioned the fairly and reasonably related, but it's got to be necessary to make the development acceptable. It must serve a planning purpose, and where possible be identified in the development plan. So that's to give people fair notice and advance warning. It must relate to the development, including cumulative impact. So you can look at a number of developments and the impact that they will have altogether on the infrastructure, but it can't be to remedy a pre-existing deficiency. Must be fairly and reasonably related in scale and kind, so that the contribution relates to the impact that that development is having. And then that classic catch-all that we always like of reasonable in all other respects. But just thinking about what Neil had been saying, kind of just there and about the policy, I've spent countless hours phoning up community halls to see that, the opening hours and to see what they do, because there's a policy that says I need to contribute towards, a library or community facility that's going to be expanded. If it's only open half the time, actually, is it, should it really be a revenue cost and not a capital cost? So I do tend to interrogate things more. If you're asking me for something or a contribution, I'll do a little bit of digging to see actually whether that is needed or not. So I kind of go into it probably in a bit more detail.
Okay, and so when would you use conditions instead? Because the tests for the planning obligations are quite similar to the tests in the circular, which deals with conditions. So when would you use conditions, and when is it an obligation, and what are the advantages and disadvantages of both?
So the circular on planning obligations, makes it clear that you should use conditions. That's your starting point. Use conditions, wherever possible. And the ELSIC decision actually touched on the lawfulness of conditions as well. So it's a pretty useful decision in terms of looking at that. And again, fairly similar, the tests. Planning purpose, fairly and reasonably related, not unreasonable. And then the circular of 4/1998 on conditions, expands them again, very similar to the planning obligations. Generally, conditions are seen as being quicker and cheaper, so they don't need, lawyers, allegedly, and everybody needs lawyers. So that, and when it was Section 75 agreements that you needed to get the council's agreement to vary, then putting it in a condition, and you could put in an application to vary the condition, a Section 42 application was actually a preferable way to keep things, because if you put it in a Section 75, if I couldn't get the council to agree a variation clause in there and then to agree the variation, I was stuck. Now, obviously, you can put in a Section 75A application if the agreement, and no doubt we'll come on to look at the reforms because things have come full circle, and we're back to kind of where we were, before. But Section 75A now gives you that opportunity to vary your Section 75 agreements.
Okay, I just want to pick up because there's been a question put in which I think kind of fits in with what we've been talking about. So somebody's asked, in terms of the the tests that we've been speaking about on Section 75 obligations, can a Section 75 agreement be used to limit future development on neighbouring sites, for example, to control the future expansion of a wind farm?
Neil, you're the wind, and Can, you're the wind farm experts, but in terms of you have to bind the burdened land. And ELSIC does go through the complicated scenarios where you can have one piece of land here and the development is here. But in terms of restricting the development on somebody else's land, you need only the landowner can bind the land.
And it also comes back as well to the fundamental that you've got to be able to justify that restriction in planning terms. When Elaine was talking about the old days, and she very politely didn't include me in that, and I kind of Neil will remember too, but I do. It was quite common for Section 50s as they were then to have very sweeping no development clauses, and the Scottish Government stepped in, and that's just contrary to Scottish Government policy, because you need planning permission for development. So the time for that to be assessed is at the time someone puts in a planning application. There's absolutely no point having an agreement saying, now there shouldn't be any development in the future. That is to be judged on its merits at some point in the future when there's an application.
It was common, wasn't it? Linked to you often got the occupancy restriction, on your house, and also, you know, confirmation that you'll not apply for any other house, you know, on it, and confirmation that it will only ever be sold together. You know, that was often a kind of common section 50, you know, kind of obligation. In fact, I'm still getting ones now where we're unraveling them, you know, at the moment.
I think that's right, and it's probably worth saying that when applications are made under Section 75A to try to tackle some of these issues in older Section 75s, the council, and if it goes to appeal, a reporter on appeal will be looking at these same tests within the circular. So it's really sort of working in reverse at that point, that if the obligation can't be justified against those policy tests at the point of considering any modification or discharge, then they should fall at that point. So it's the same policy tests that apply at either end.
Okay.
Yeah.
So I'm going to move the discussion on slightly. We have mentioned in passing the changes in planning legislation, but Neil, one of the changes brought in by the Planning Scotland Act 2019 is the power for the Scottish ministers to make provision for an infrastructure levy. Much needs to be considered before regulations can be brought into play. So what do you see as the key considerations which need to be thought through in terms of any infrastructure levy?
Well, I think it's useful to start by thinking about advantages and disadvantages. The advantages, the main advantage is the opportunity to move away from the link between the development and the infrastructure that we've been talking about, because one of the issues planning authorities have faced is how to fund infrastructure in areas that don't have a lot of market interest for development. And it's that pump priming. You can't take money from a hot housing area and move it to provide infrastructure to unlock development in a, whatever the opposite of hot is, cool development area. That was easy, should have known that. So the infrastructure levy provides that opportunity. It's also, in part, it picks up that specific LSIC point about strategic transport infrastructure. You know, for instance, the infrastructure levy could be taken by a local authority to help pay for a railway station in a different local authority area, but it's close enough that it will benefit the authority that's providing the money. So it's those wider opportunities where it is useful. There's also an element of it being to advantage of developers, because it gives them a bit more certainty and predictability than the current system. Although the formula-based approach for Section 75s through supplementary guidance does provide a lot of that certainty and predictability. So maybe in those local authority areas, it's you know, a bit more of a weaker benefit in that sense. For me, the biggest disadvantage is the same thing, actually, removing the focus from the link, because at the moment, if there's a housing development and there's not enough room in the local school, the developer provides the contribution to provide that space and the planning permission can be granted. If there is no contribution but there's a levy payment, the levy doesn't guarantee that school upgrade will be provided. It just vanishes into a pot. So for me, in that situation, the planning authority or the reporter on appeal is just going to have to refuse planning permission on the grounds that there is insufficient capacity, so the permission can't be granted. So at the moment, nobody has explained how introducing a levy addresses that situation, unless you run the levy in association with Section 75s. But that sort of raises the query of, well, what's the point then, unless it is just purely an exercise in getting more money, which
I'm going to
some
jump
people
in.
have said.
I was going to jump in there, Sarah, because I view it the opposite way, Neil, in terms of if I've paid my levy, then there shouldn't be any barrier to me getting my consent, because that levy's been calculated knowing that I'm going to have an impact on that school. So once I pay my contribution, my levy, I should be able to bash on, and it's, to me, that should clear any barriers, so it shouldn't be a reason for refusal. That's how I'd like to see the levy, you know, working, if it was to work, you know, kind of that way.
I suppose there's still the issue about how suspensive conditions would be used in that sort of scenario. I think it's reasonably clear that we're likely to end up with a sort of two-tier system, if you like, and that even if the infrastructure levy comes in, I don't think we'll be saying goodbye to Section 75s, even if they're aimed at different types of infrastructure or very development-specific requirements. But you're going to have to work with a layering of these, and it's a lot of it is going to come down to timing and the timing of delivery, and if conditions will still provide some kind of answer to that.
So we've had another question which kind of ties in with this. So we've been asked, does the panel consider that there's a case justifying or triggering the sunset clause in the Act for the infrastructure levy mechanism in order to fund and facilitate strategic infrastructure? And it appears to me it's a bit like what Donald Rumsfeld said. We know there are known knowns. We also know there are known unknowns, but there are also unknown unknowns. So there's quite a lot going on here. But you know, is there a case for triggering that sunset clause? Are we going to see the infrastructure levy coming through, or is there just too much to deal with still?
Maybe to go through your Donald Rumsfeld in terms of the various categories. What we know at the moment, the Act at Section 654, again, we're lawyers, we've got to have some law. What it says is the infrastructure levy will be payable to the local authority by development in its area to be used by that local authority to fund infrastructure. That is more or less all the Act says. It's very, very enabling, it's very broad, and the detail is to be filled in. What we don't know yet, indeed, is will it ever go ahead? And I'd be interested if anyone wants to shove something on the Q&A if they know different. But I've never heard or seen a specific commitment from Scottish Government to actually introduce the levy. It's always been approached as an option that they want to pursue, and they wanted the power to be in place. And as the question mentioned, the Act actually contains a sunset clause, and that's shorthand for the power to introduce the levy expires if regulations aren't made by July 2026, which is quite far away. But in terms of drafts being consulted on and all the rest of it, time vanishes fast. So it will be interesting to see if Scottish Government do in fact go ahead. So that's one of the known unknowns, I suppose. In terms of other things, just quickly, we don't know what types of development will be liable to pay. We know that typically house building developments tend to pay. Wind farms, in contrast, don't tend to really pay anything because they don't tend to impact on infrastructure. There are community benefit payments, that's different. There's all sorts of other developments in England with SIL. Apparently, there is the weird situation that infrastructure developments have to contribute towards infrastructure. Get your brain around that. So that's types of development, question mark. Who's going to pay? Is it the developer? Is it the landowner? Is it the ultimate owner? We don't know. That's partly because we don't know when liability to pay would arise. And obviously, through the various parts of a project in terms of, is it when consent's granted? Is it when the development starts? Is it development occupied? There's a whole series of options there. How will the amount be calculated? So one of the disadvantages, sorry, I'm being very planning anorak. SIL is the infrastructure levy system in England, and it has a lot of detail in it for you to calculate through what you pay. But as ever, when there's a lot of detail, there's a lot to argue about, and also it takes a lot of work to produce that detail in the first place. and we've got the whole, who actually is going to do the work on this? Is it the local authorities or is it the Scottish Government? We know from the Act that the money would be paid to the local authority, but it's very important to work out where that burden is going to go in terms of actually getting the whole system up and running. And then a big one is, will local authorities be able to take account of local circumstances? As I said, particularly within Scotland, maybe in contrast to parts of England, the heat of the market, if I can put it that way, can vary tremendously within a few miles. So an infrastructure levy payment might be accommodated within the viability of a development, and then a few miles down the road, it could completely and utterly stymie development by making it unviable. So there is that question of how do you take account of local circumstances to make sure that development still happens? Because ultimately, particularly with the likes of housing, but lots of other development, we need it. We need it for economic development and all the rest, and we can't kill it off by making it non-viable.
And I think certainly, Neil, one of the issues that was experienced with SIL or has been experienced with SIL down south has been where exceptions start to be introduced into the system, the application of when the levy will be collected, in an attempt, no doubt, to try and take account of some of these things, but ending up in a situation where really nothing or nothing of any significance is being collected, such that it's then undermining the objective of the levy altogether and affecting delivery. So it can, it can go too far in one direction. You just end up with the problem of the infrastructure not coming forward. So that's certainly a difficult one. I just noticed some comment coming in that there's been a lot of Scottish Government work already done, certainly on this area, and I think one of our attendees, Rob McIntosh, is just making the point that a lot of work has been ongoing with the local authorities just on the effectiveness of their developer obligations. So Scottish Government certainly got a wealth of information about it all at the moment, but I think the $10 billion question remains whether it's going to come forward or not.
Okay, just another question as well, which is quite topical and picks up on infrastructure, but also the tests for, what you can use a Section 75 for. Somebody's asked in relation to health services. So Section 75 contributions can include contribution for bricks and mortar health services, for example, a surgery. During the pandemic, health service delivery is changing to include mobile services. And how can the health boards secure contributions when their service delivery is no longer via a new building? I presume this is could still be met under the Section 75 tests. Elaine, do you want to pick that up? Since you talked about tests earlier.
Yeah, I think you will see it as being health, kind of provision. And I know that health has been challenged, by, and through various appeal decisions. And they've said, health is similar to education, is similar to community facilities if you're creating, kind of a need for it. What I'm quite excited, and in that way that planners get excited about things, is that the change and the move actually in planning towards health and well-being, and we are going to see, health being provided in different ways through smart homes. So rather than building new hospitals, new facilities, actually we're going to be doing things in homes and having, once people get into the health system, they don't come out. So the intention is really to be building developments, so your walkable neighbourhoods and all that, to make people healthier, to keep them out of the kind of health system. But there are other ways. So, will it be with iPads and, being able to do, we've obviously had video calls now with your doctors, all of those aspects. So I think you'll probably see it changing, and it might be more in terms of conditions and things that you expect to see in design, kind of policies as well. But yeah, I think Section 75 and planning obligations or levies will continue to evolve to see how developments, kind of change.
Yeah,
I think it's quite interesting though, because it picks up, Elaine, on what you were saying earlier about always interrogating. The danger is that the planning authorities keep asking for the same thing because that's what the supplementary guidance says, or that's what they've always asked. But as things move on, as it were, it's interrogating and saying, but where's the evidence, back to what we said before, that that is still what you need? So if indeed the health service becomes more mobile, it's not about funding the bricks and mortar health centre that 5 years ago everyone thought it would be. It's always looking, saying, can we actually still support asking for that thing that we asked for 5 years ago, or do we need to change the ask? The difficulty, though, is, and Elaine, I can remember we were talking about this, I think it was a few months ago. The difficulty becomes, as things evolve, the planning officer is reaching out to other services within the authority saying, tell me what you need. And they're saying, well, we don't know, we'll have to go away. And that's a particular problem at the moment with education, that the developer's sitting saying, okay, I know I'm going to have to pay something, just tell me what it is. The planning officer has gone to education to say, tell me what it is. And education say, well, we're not sure, we don't have the data, we think we might have the data. And 6 months later, everyone's still talking and no one's actually found the answer. So that can be a big frustration.
That was, during the pandemic, the education was that one, in terms of actually, we don't know, because we don't know what the class sizes are going to be. So how can we kind of predict? I was just going to make the point, when you were there saying of, do we still need something in 5 years? Remember, and I know, Karen, I think you're going to come on and look at this in more detail, but we're lawyers, we like to pin things down so that if there's a Section 75 agreement that obliges me to, extend the health centre, that's what it will say. And if you don't extend it within 5 years or 7 years, I'll have my money back. So you can't then chop and change it. It will be, it's a contribution to be used towards whatever is specified, in that Section 75 agreement.
Yeah. So we've spoken obviously about the infrastructure levy and how potentially we might end up with a two-tier system. So it looks like Section 75s are going to remain a permanent feature. But if we were to associate them with an animal, I'd guess many would suggest that they're akin to a snail or a tortoise, given the speed they often move at. So Karen, what do you think we can do to get them viewed as the cheetahs of the legal world?
Just wondering where this was going.
I was more concerned about the cheetah bit, as in, yes, is it a cheetah or a cheetah?
Yes, it could have been a lot worse. I mean, delays. I think delay is always the thing that people associate with Section 75s, and particularly, for developer clients, obviously, the planning permission needs to be out the door yesterday or 2 weeks ago or whatever it is. So, I mean, there are a number of things that can be done on both sides. It's certainly not the case that delay is always down to the planning authority, and that the developers, there are times when they will move less quickly on things for their own reasons, if perhaps priorities have changed, etc., etc. But I think the thing that I would, just keep coming back to on this is the need for detailed heads of terms as to what it is that's to be covered by the agreement. And it's such an obvious thing, but routinely, we come across incomplete or sort of half-baked, if I can put it that way, heads of terms, which don't enable an agreement, don't enable you to come forward with a decent first draft. So, it's one thing to identify if payments are to be made, which typically they will have to be made, what the amounts are and what those payments have relate to. But really at the heads of term stage, discussions should be getting into what are going to be the triggers for those payments, the timescales for things to come forward. There should be discussion about indexation if it's not clear from policy what the position is on that. Obviously, if getting into other specifics that you might have, if there's to be a transfer of land, that should have been identified. Where is it? What are the boundaries? When is that to happen? All of these things, and it's obvious stuff, but it's amazing how many times discussions just have not developed, or perhaps the planning officer has come away with one understanding of what it is that's been agreed, and the developer has quite a different understanding, and that's really only flushed out when you get to the stage of the first draft having been circulated, and then it becomes quite apparent that really there is no agreement at all. So I think that's one of the things that would probably make the most difference overall, would be if, you know, routinely those heads of terms, they need to be looked at as early a stage as possible and documented in a reasonable amount of detail, so that everybody can understand what it is that they're talking about, and if there are those areas of disagreement, they need to be flushed out before anyone even gets to the drafting stage.
And to what extent do you think the use of templates or model agreements can help?
Certainly a number of authorities have gone down that road in having model agreements that they use. It certainly does help, but really only to an extent, in that, I mean, what a model agreement typically is doing is setting out, well, these are our sort of boilerplate clauses, these are the standard clauses. A developer can potentially, you know, pick up that template, and indeed, if the authority is willing to let them do it, have their, you know, first go at the agreement, knowing that it's going to tie in with those standard provisions. But largely everything else is still going to need to be negotiated, and the case specifics will always need to be taken into account. So templates, yes, they're helpful, particularly where an authority has perhaps gone out, you know, to the industry with its template to say, look, you know, this is what we're thinking about. Does this work? Getting feedback on it, etc. But equally, it has to be said that if templates then are being used in an overly rigid way, then they can really become a hindrance as much as a help. And authorities shouldn't feel constrained that they can't, you know, depart from template wording. If there's a reason to do it in a specific case, then they should feel free. They should feel free to do that if the circumstances justify it. It's really a starting point for discussion. But certainly it's, you know, it's been a useful, I think, direction of travel. And as I say, a number of authorities do have templates. It's probably fair to say that they need to be shaken down, you know, frequently, to make sure that they're still fit for purpose. They need to be kept under review. And we have seen recently that, you know, unfortunately, where there is a template, sometimes even where it's recognised that there may be issues with particular clauses, the machinery of changing that template can be quite difficult and cumbersome. So that again can be, that, you know, that in itself can be a problem.
So we're aware of some like really good practice in certain council areas where there's a legal forum or a developers forum, and these have been set up, and discussion of Section 75s and how to tackle particular issues are addressed. Is this something you would like to see more of? Do you think that can help with some of these issues?
I mean, I think there's no doubt that dialogue amongst the relevant stakeholders can only ever be a good thing. It's, you know, it's a good opportunity to troubleshoot issues in that way, sort of out of the heat, if you like, of particular transactions. You know, issues can be talked through, and to help, I think anything that sort of aids the understanding of you know, the two sides of the equation, if you like. So it's perhaps seeing the developer perspective on something, why something may have difficulties commercially, perhaps for funders, but also there needs to be that developer understanding of what it is that the planning authority itself is trying to achieve, and to be able to have a level of consistency and certainty, you know, where it's sort of essentially forward funding infrastructure, for example. So I think really anything that aids that understanding, that sort of two-way dialogue, is going to be useful. I think it also helps with the opportunity perhaps to future gaze as to what might be coming down the track, possibly in relation to some of the new sort of, you know, development sectors that will, you know, emerge over time. And we're seeing at the moment with, you know, the likes of some of the newer asset classes that have emerged over recent years. Styles of agreement have come forward to deal with those in particular, but it's always much better if these things can be discussed up front before an authority perhaps adopts a particular position that then maybe isn't going to work for that industry, you know, commercially.
I think that's so I think that's the one that I get annoyed at, is where it's something new and effectively we're drafting in the context while the clock is running. and actually it'd be better to have these, developed in a forum, and when you're not, it's not responsible for a client and we're not running up kind of charges, but when it's being done, for the first time, then, that's the bit, I suppose, that I think development forums and, having that agents things really helps.
I think that's a good point. Nobody wants to be the kind of test case for a new type of agreement or a new sort of type of development that's coming forward and have all the thinking done on their transaction, as it were.
Well, that's certainly a problem we've had at the moment, that we've been delving into a lot of detail with a planning authority on behalf of a developer client, and it's the slightly different approach to provision of affordable housing through mid-market rent as part of a build-to-rent development. And it is exactly that we're unfortunately one of the first, so we've had to take the pain of helping the drafting, and it's involved a lot of work as the planning authority learn, because they don't know how the development operates. Our client does, but as you're saying, our client's bearing the delay plus the cost of us helping out with the drafting.
That kind of picks up on one of the questions before I move on to kind of some more drafting issues. Somebody has raised an issue and saying back in the day, there was a view that planning authorities were under-resourced and perhaps underconfident when it came to dealing with Section 75s. Are there different blockers now? Does that still seem to be an issue? Is there more collaboration needed on that front? Neil, do you want to, or Karen?
I think the issue of resourcing is, I don't know if that's a back in the day issue. I think that's it's never changed issue. I mean, resourcing is always going to be a problem for local authorities, but Section 75s, I think particularly in some of the larger authorities, they're I'm not so sure that there's a lack of confidence around dealing with Section 75s, but there isn't always I suppose the luxury of having perhaps specialists on the planning front. Some authorities definitely do have that, have very experienced planning lawyers that participate in the likes of the Law Society subcommittee and all the rest of it. So I think it varies across authorities. That would probably be fair to say.
I think it's a bit chicken and egg, because going back to what we were saying, the template agreements can help local authorities save on some staff time because they hit the ground running, but not every authority has enough Section 75s on the go to justify doing a template. And in those authorities, it's maybe a bit more going back to the filing cabinet, finding the last one they did, and preparing a draft from that. So there is that issue, I think, of statistically, the level of using agreements varies enormously between different councils throughout Scotland.
Well, I was just going to say, I think, if possible, even if there's the lack of resourcing, if it can be the same team, within the legal team that does the Section 75s, so we have close relationships, particularly, obviously up here with the legal team in the city and the Shire. And it almost feels as if you're starting halfway through the agreement, because you don't need to have the bits backwards and forwards, because we know we've negotiated the terms of that clause, and it just makes everything much quicker and much smoother, and you develop a working relationship with the people that you're working with kind of all the time. So it does help that somebody's doing it and you're not kind of having to pick it up with somebody new each time.
Yeah, having that relationship definitely helps. Yeah.
And maybe can I pick up on the confidence point, because it's something I'm acutely aware in a few of the projects I'm doing at the moment for developers, that one of the problems we're having is persuading lawyers at the council to take a less cautious approach to risk. And that is a really difficult one, because on the one hand, yes, we understand the lawyer's job is to protect the client. The council lawyer is there to protect the council's interests. But on the other hand, if there's no development, then there's no economic development in the council area, and the Section 75 is being discussed because the councillors have said they're minded to grant permission. So delivering that decision requires the agreement to proceed. And the obstruction we find quite often is the local authority lawyer trying to completely de-risk it from the council's perspective, but as a result, pushing the development into being unviable or undeliverable. So that on occasion can be a real problem. And I think in part it does come back to a lack of confidence to be able to, it's going back to the thing we talk about a lot, take a view. And to be pragmatic or to be commercial or however you talk about it, but it is so important.
Yeah, and Karen, there's certainly a bit more of a challenge when it comes to dealing with either a really complex agreement or a particularly large site. So do you want to talk about some of the challenges that we face in the drafting in relation to those kind of projects?
I mean, I think typically for your sort of large scale strategic sites under a PPP, there are particular things that need thought about in the agreement, and often when we're looking at these agreements after the fact, perhaps with a client looking at buying into the site, you can see that there is a problem in that the thought or sufficient thought hasn't been given to the allocation of obligations within the agreement. So typically when you're talking about a large scale site like that, it's going to be parceled up and sold off to, you know, multiple developers over time coming in and looking to do their particular bit, whether it's under you know, under an AMSIC or indeed developers going for a new detailed permission. But for somebody looking at buying into that situation, if they're faced with what will typically be a very chunky and onerous Section 75, and all of the obligations are just stated to be enforceable against the owner of the whole site, and so potentially enforceable against every developer who's buying in without any distinction being made as to their development parcel, then that's obviously a problem. So, you know, these things need to be thought about at the drafting stage. There's a number of ways in which they can be dealt with. That, you know, it's not rocket science. It comes down to the drafting. It can be, you know, identifying development parcels if that's known from a master plan. It can be as simple sometimes as talking about, you know, owners without using the capitalized term, and just the owners of particular elements of the consented development, or making it clear that particular obligations are only enforceable against particular development owners in due course. But it's one of the things that we often see going wrong with agreements for these large scale sites. And when it pops up in the contract in the context of a purchase perhaps, or a funding, you know, when the die's already been cast, then you're having to look around for a fix, whether that's trying to get a modification, you know, through quickly, which is never guaranteed, or then you're into looking at warranties and things within the context of your transaction, which, you know, ultimately nobody wants.
Yeah, and you know, you talked there about the complexities and, you know, the ability to maybe allocate it to phases and things. But with these large development sites, you know, things change over time, and some of them are not built out quickly. So what can we do to kind of future-proof these agreements?
Future-proofing, I think, you know, again, as you say, where it's going to be a long-term build. I mean, some of these large-scale sites, you know, that some of the ones that Elaine being involved in Counties Wales, for example, up in Aberdeen, or Ravenscraig, or I'm thinking of Shawfair through in Midlothian. These are sites which are going to be built out over perhaps a 20 or 30-year period. So things inevitably are going to change. There may have been assumptions that were made when contributions were initially thought about, whether it's in relation to education or other elements of the obligations. So, you know, there are things that can be done in the drafting to build in the opportunity for review at certain trigger points, if that's going to be appropriate. I think that's always going to be a matter for negotiation with the authority as to what they will be happy to sign up to, because it's a two-way street at the end of the day. They are also making assumptions about what they're going to get in and what they're going to be able to cover off with the payments that they're collecting. But there should normally be some kind of scope for middle ground as to what is sensible to take stock at a certain point, and if either it's a case of for viability reasons things are not where everyone thought they would be, that then triggers a review of payments. It may even be down to using some sort of formula that numbers will then be revised, and contributions will typically would be talking about a decrease, I guess, in relation to this sort of thing. Of course, there is the ability to come in and try to modify, but that is always going to be much more of an unknown for the developer, because they're having to make their case at that point. I think the benefit of setting out in advance in some sort of review clause is that everybody then knows how that will be dealt with should those trigger events come to pass. I think that's something that you've been using, Elaine, in agreements that you've been dealing with.
Yeah, this particularly, as you mentioned, the large ones where we're talking about 3,000 houses, we're talking about 4,000 or 7,000 houses, and trying to predict at that point, the education position, because often the education forecasts only look 5 years hence, and I think you end up often with a number, and you say this development is going to produce this number of children, and that means I need this number of schools. But in fact, there's that remembering that, if you think about a primary school 7 years, those children are going through school and leaving that space behind in 7 years' time that can be, be backfilled. So you kind of need that constant review. So generally our review clauses will look at, a liaison between the council and the developer, giving the completions, looking at the number of children that are produced, and then reassessing. So it's almost like the Section 75 has the worst case scenario, and then you're looking and saying, well, okay, we might not need that second school, or the school might not need to be so big, and then rejigging it. The other one often is transport. And you're basing it on a certain number of developments and a certain number of transport interventions, but there might be more developments, so you often need to have a bit of an accounted reckoning going forward. And if the council approves other developments which also contribute, then my guy is going to want his figures to be recalculated at the end. So it is that kind of sort of trying to look ahead, and it is really the big ones that are the key. One of the reasons why we introduced review clauses was to avoid Section 75As, because it was already telling you in the agreement what you needed to do to review it, and I didn't have to put in a Section 75A.
I think that's it. It's the certainty, but I think undoubtedly it's that there's a middle line to be walked on all of that, because again, from the authorities' point of view, obviously they don't want the rug to be pulled out from underneath them, having thought that they were getting in a certain amount, and particularly where they're essentially forward funding infrastructure. So I think there's the need for that recognition as to how the whole thing has to work, but certainly there's scope for discussing that sort of review clause.
And I always put in a clause that says my contributions are never going to go up. They can only come down.
We have had a question into the Q&A about enforcement of obligations, and just how often are they enforced by planning authorities, and are they monitored systematically, which seems like a good time to address that.
I think it's probably, I'm just going to feel I'm being blinded by the sun. There we go. It's not often I have to stop the sun coming in the window in Glasgow. But
showing off about the sun. I've just had hailstones in Edinburgh. I'm depressed.
Be depressed. I think it's probably fair to say it's a mixed bag. I don't know what Neil and Elaine would say. I think monitoring the monitoring of obligations, the collection of contributions, etc. It's definitely a headache, if I can put it that, for authorities. I think they do find it a challenge to have the systems in place to keep an eye on what is happening on all of the sites, and to have the sort of financial systems in place to be keeping track and making sure that what should be being done is being done. it's certainly not routine that parties are ending up in court, with local authorities taking action over obligations, but that's not to say that it doesn't happen. I think it would very much depend on, the circumstances and the type of obligations. I mean, we're typically thinking, I guess, here of housing developments and, your roof tax payments and all the rest of it. But it's not to forget that we sometimes have Section 75s covering things like, well, how can we forget the litigation of a few years back on, restoration of open cast mines and all the rest of it. So there are very different types of obligation that you might come across in agreements, and there'll be situations which authorities have to take very seriously on occasion and will absolutely pursue if they need to. It's also the case that, of course, obligations are usually a two-way street at some point in the agreement, and there may be situations where the developer will be wanting to enforce an obligation for the authority, whether it's about, well, the typical example would be to repay funds if in fact a certain amount of time has passed and the money hasn't been put to the use to which it should have been put. So, I mean, you're talking about a contract. At the end of the day, it's the typical contractual remedies that are available, so suing for payment, but there may be a reason to, withhold other payments, or, depending if there's been a material breach, etc. So it will always come down to the drafting, and if things have been drafted in a sufficiently clear manner to allow you to sue upon the obligation, really.
I think that's just, you said, is a two-way, because I've had this, recently for a couple of them, where the obligation is on the planning authority to provide a school by a certain date, and it's not happening, and so at the end of the day, the council needs to remember it is a contract that, and specific implement, there are all those other aspects. Generally, in the drafting of the Section 75 agreement, you might say, well, if you haven't paid that, you've got interest running, or you can't go on to the next phase. We see that a lot with affordable housing. If you haven't provided the affordable housing by a certain deadline, you can't go on to the next one. So again, if you can try and cover in the Section 75 agreement, what happens in the event of, I think that's where you get heads of terms as one page, and then the agreement's like 100, because as lawyers we go, what if? But what if? And you're always looking at that aspect as well.
Yeah, good plug for why you need us, I suppose, to draft your agreements well. But I hate to be the one to do this, but I'm just conscious of time, so I think we're going to have to draw the session to a close there. But if you have submitted a question and we haven't got to it, then we will follow up with you separately. I think that was a really interesting and lively discussion, so thank you all for joining us, and thank you especially to our panel and to Sarah. Our next Planning Live is going to be on the 3rd of June, and we're going to be joined by Patrick Flynn, Director of City Development at Glasgow City Council, so we hope you can join us for that. If you do, in the meantime, want to get in touch with us, then please do. You can find our contact details on the slide there, or you can, of course, find us via the website. But otherwise, I'll say good afternoon. Thanks very much for joining.
Thank you.
Thanks.